What is Property? An Inquiry into the Principle of Right and of Government, by Pierre-Joseph Proudhon. Second Memoir, Part 7. Now let me make an hypothesis. Suppose it were written in the charter, in case the country be again invaded, and Paris forced to surrender, the government being annihilated and the National Assembly dissolved, the electoral colleges shall reassemble spontaneously and without other official notice, for the purpose of appointing new deputies, who shall organize a provisional government at Orleans. If Orleans succumbs, the government shall reconstruct itself in the same way at Lyons, then at Bordeaux, then at Bayonne, until all France be captured, or the enemy driven from the land. For the government may perish, but the nation never dies. The king, the peers, and the deputies massacred. Vive la France! Do you not think that such an addition to the charter would be better safeguard for the liberty and integrity of the country than walls and bastions around Paris? Well, then, do henceforth for administration, industry, science, literature, and art that which the charter ought to prescribe for the central government and common defense. Instead of endeavoring to render Paris impregnable, try rather to render the loss of Paris an insignificant matter. Instead of accumulating about one point academies, faculties, schools, and political, administrative, and judicial centers, instead of arresting intellectual development and weakening public spirit in the provinces by this fatal agglomeration, can you not, without destroying unity, distribute social functions among places as well as among persons? Such a system, in allowing each province to participate in political power and action, and in balancing industry, intelligence, and strength in all parts of the country, would equally secure, against enemies at home and enemies abroad, the liberty of the people and the stability of the government. Discriminate then between the centralization of functions and the concentration of organs, between political unity and its material symbol. Oh, that is plausible, but it is impossible. Which means that the city of Paris does not intend to surrender its privileges, and that there is still a question of property. Idle talk. The country, in a state of panic which has been cleverly worked upon, has asked for fortifications. I dare to affirm that it has abdicated its sovereignty. All parties are to blame for this suicide: the conservatives by their acquiescence in the plans of the government; the friends of the dynasty because they wish no opposition to that which pleases them, and because a popular revolution would annihilate them; the democrats because they hope to rule in their turn. [Footnote: Armand Carrel would have favored the fortification of the capital, Le National has said again and again, placing the name of its old editor by the side of the names of Napoleon and Vauban. What signifies this exhumation of an anti-popular politician? It signifies that Armand Carrel wished to make government an individual and irremovable, but elective, property, and that he wished this property to be elected, not by the people, but by the army. The political system of Carrel was simply a reorganization of the Praetorian Guards. Carrel also hated the Pekins. That which he deplored in the Revolution of July was not, they say, the insurrection of the people, but the victory of the people over the soldiers. That is the reason why Carrel, after 1830, would never support the patriots. "Do you answer me with a few regiments?" he asked. Armand Carrel regarded the army, the military power, as the basis of law and government. This man undoubtedly had a moral sense within him, but he surely had no sense of justice. Were he still in this world, I declare it boldly, liberty would have no greater enemy than Carrel. That which all rejoice at having obtained is a means of future repression. As for the defense of the country, they are not troubled about that. The idea of tyranny dwells in the minds of all, and brings together into one conspiracy all forms of selfishness. We wish the regeneration of society, but we subordinate this desire to our ideas and convenience. That our approaching marriage may take place, that our business may succeed, that our opinions may triumph, we postpone reform. Intolerance and selfishness lead us to put fetters upon liberty, and, because we cannot wish all that God wishes, we would, if it rested with us, stay the course of destiny rather than sacrifice our own interests and self-love. Is this not an instance where the words of Solomon apply? La iniquité est mentie à elle-même. It is said that on this question of the fortification of Paris, the staff of Le National are not agreed. This would prove, if proof were needed, that a journal may blunder and falsify, without entitling anyone to accuse its editors. A journal is a metaphysical being for which no one is really responsible, and which owes its existence solely to mutual concessions. This idea ought to frighten those worthy citizens who, because they borrow their opinions from a journal, imagine that they belong to a political party, and who have not the faintest suspicion that they are really without a head. For this reason, sir, I have enlisted in a desperate war against every form of authority over the multitude. Advanced sentinel of the proletariat, I cross bayonets with the celebrities of the day as well as with spies and charlatans. Well, when I am fighting with an illustrious adversary, must I stop at the end of every phrase, like an orator in the Tribune, to say the learned author, the eloquent writer, the profound publicist, and 100 other platitudes with which it is fashionable to mock people? These civilities seem to me no less insulting to the man attacked than dishonorable to the aggressor. But, when rebuking an author, I say to him, "Citizen, your doctrine is absurd, and, if to prove my assertion is offense against you, I am guilty of it." Immediately the listener opens his ears; he is all attention, and if I do not succeed in convincing him, at least I gave his thought an impulse, and set him the wholesome example of doubt and free examination. Then do not think, sir, that in tripping up the philosophy of your very learned and very estimable confrère, M. Troplong, I fail to appreciate his talent as a writer. In my opinion he has too much for a jurist; nor his knowledge, though it is too closely confined to the letter of the law and the reading of old books. In these particulars M. Troplong offends on the side of excess rather than deficiency. Further, do not believe that I am actuated by any personal animosity towards him, or that I have the slightest desire to wound his self-love. I know M. Troplong only by his treatise on prescription, which I wish he had not written; and as for my critics, neither M. Troplong nor any of those whose opinion I value will ever read me. Once more, my only object is to prove, as far as I am able, to this unhappy French nation, that those who make the laws, as well as those who interpret them, are not infallible organs of general, impersonal, and absolute reason. I had resolved to submit to a systematic criticism the semi-official defence of the right of property recently put forth by M. Wolowski, your colleague at the Conservatory. With this view I had commenced to collect the documents necessary for each of his lectures, but, soon perceiving that the ideas of the professor were incoherent, that his arguments contradicted each other, that one affirmation was sure to be overthrown by another, and that in M. Wolowski's lucubrations the good was always mingled with the bad, and being by nature a little suspicious, it suddenly occurred to me that M. Wolowski was an advocate of equality in disguise, thrown in spite of himself into the position in which the patriarch Jacob pictures one of his sons, inter duas clitellas, between two stools, as the proverb says. In more parliamentary language, I saw clearly that M. Wolowski was placed between his profound convictions on the one hand and his official duties on the other, and that, in order to maintain his position, he had to assume a certain slant. Then I experienced great pain at seeing the reserve, the circumlocution, the figures, and the irony to which a professor of legislation, whose duty it is to teach dogmas with clearness and precision, was forced to resort; and I fell to cursing the society in which an honest man is not allowed to say frankly what he thinks. Never, sir, have you conceived of such torture. I seemed to be witnessing the martyrdom of a mind. I am going to give you an idea of these astonishing meetings, or rather of these scenes of sorrow. Monday, November 20th, 1940, the professor declares in brief: 1. That the right of property is not founded upon occupation, but upon the impress of man. 2. That every man has a natural and inalienable right to the use of matter. Now, if matter can be appropriated, and if, notwithstanding, all men retain an inalienable right to the use of this matter, what is property? And if matter can be appropriated only by labor, how long is this appropriation to continue? Questions that will confuse and confound all jurists whatsoever. Then M. Wolowski cites his authorities. Great God! what witnesses he brings forward! First, M. Troplong, the great metaphysician whom we have discussed; then M. Louis Blanc, editor of the Revue du Progrès, who came near being tried by jury for publishing his Organisation of Labor; and who escaped from the clutches of the public prosecutor only by a juggler's trick. [Footnote: In a very short article which was read by M. Wolowski, M. Louis Blanc declares in substance that he is not a communist, which I easily believe; that one must be a fool to attack property, but he does not say why; and that it is very necessary to guard against confounding property with its abuses. When Voltaire overthrew Christianity, he repeatedly avowed that he had no spite against religion, but only against its abuses. Corinne, Madame de Staël, who, in an ode, making a poetical comparison of the land with waves, of the furrow of a plough with the wake of a vessel, says, that property exists only where man has left his trace, which makes property dependent upon the solidity of the elements. Rousseau, the apostle of liberty and equality, but who, according to M. Wolowski, attacked property only as a joke, in order to point to a paradox; Robespierre, who prohibited a division of the land, because he regarded such a measure as a rejuvenescence of property, and who, while awaiting the definitive organization of the republic, placed all property in the care of people, that is, transferred the right of eminent domain from the individual to society; Babeuf, who wanted property for the nation and communism for the citizens; M. Considerant, who favors a division of landed property into shares, that is, who wishes to render property nominal and fictitious, the whole being intermingled with jokes and witticism, intended undoubtedly to lead people away from the hornets' nests, at the expense of the adversaries of the right of property. November 26th, M. Wolowski supposes this objection: land, like water, air, and light, is necessary to life, therefore it cannot be appropriated; and he replies, the importance of landed property diminishes as the power of industry increases. Good! This importance diminishes, but does not disappear, and this of itself shows landed property to be illegitimate. Here M. Wolowski pretends to think that the opponents of property refer only to property in land, while they merely take it as a term of comparison; and, in showing with wonderful clearness the absurdity of the position in which he places them, he finds a way of drawing the attention of his hearers to another subject without being false to the truth which it is his office to contradict. Property, says M. Wolowski, is that which distinguishes man from the animals. That may be, but are we to regard this as a compliment or a satire? Mahomet, says M. Wolowski, decreed property, and so did Genghis Khan and Tamerlane, all ravagers of nations. What sort of legislators were they? Property has been in existence ever since the origin of the human race. Yes, and so has slavery and despotism also, and likewise polygamy and idolatry. But what does this antiquity show? The members of the Council of the State, M. Portalis at their head, did not raise, in their discussion of the Code, the question of the legitimacy of property. Their silence, says M. Wolowski, is a precedent in favor of this right. I may regard this reply as personally addressed to me, since the observation belongs to me. I reply: as long as an opinion is universally admitted, the universality of belief serves of itself as argument and proof. When this same opinion is attacked, the former faith proves nothing; we must resort to reason. Ignorance, however old and pardonable it may be, never outweighs reason. Property has its abuses, M. Wolowski confesses. But, he said, these abuses gradually disappear. Today their cause is known. They all arise from a false theory of property. In principle, property is inviolable, but it can and must be checked and disciplined. Such are the conclusions of the professor. When one thus remains in the clouds, he need not fear to equivocate. Nevertheless, I would like him to divine these abuses of property, to show their cause, to explain this true theory from which no abuse is to spring; in short, to tell me how, without destroying property, it can be governed for the greatest good of all. Our civil code, says M. Wolowski, in speaking of this subject, leaves much to be desired. I think it leaves everything undone. Finally, M. Wolowski opposes on the one hand the concentration of capital, and the absorption which results therefrom, and on the other he objects to the extreme division of the land. Now, I think that I have demonstrated in my first memoir, that large accumulation and minute division are the first two terms of an economical trinity, a thesis and an antithesis. But while M. Wolowski says nothing of the third term, the synthesis, and thus leaves the inference in suspense, I have shown that this third term is association, which is the annihilation of property. November 30th. Literary property. M. Wolowski grants that it is just to recognize the rights of talent, which is not in the least hostile to equality, but he seriously objects to perpetual and absolute property in the works of genius, to the profit of the author's heirs. His main argument is, that society has a right of collective production over every creation of the mind. Now, it is precisely this principle of collective power that I developed in my inquiries into property and government, and on which I have established the complete edifice of a new social organization. M. Wolowski is, as far as I know, the first jurist who has made a legislative application of this economical law. Only, while I have extended the principle of collective power to every sort of product, M. Wolowski, more prudent than it is my nature to be, confined it to neutral ground; so that which I am bold enough to say of the whole, he is contented to affirm of a part, leaving the intelligent hearer to fill up the void for himself. However, his arguments are keen and close. One feels that the professor, finding himself more at ease with one aspect of property, has given the rein to his intellect, and is rushing on towards liberty. 1. Absolute literary property would hinder the activity of other men, and obstruct the development of humanity. It would be the death of progress; it would be suicide. What would have happened if the first inventions, the plough, the level, the saw, etc., had been appropriated? Such is the first proposition of M. Wolowski. I reply, absolute property in land and tools hinders human activity, and obstructs progress in the free development of man. What happened in Rome and in all the ancient nations? What occurred in the Middle Ages? What do we see to day in England in consequence of absolute property in the sources of production? The suicide of humanity. 2. Real and personal property is in harmony with the social interest. In consequence of literary property, social and individual interests are perpetually in conflict. The statement of this proposition contains a rhetorical figure, common with those who do not enjoy full and complete liberty of speech. This figure is the antiphrasis or the contre verite. It consists, according to Dumarsais and the best humanists, in saying one thing while meaning another. M. Wolowski's proposition, naturally expressed, would read as follows: just as real and personal property is essentially hostile to society, so, in consequence of literary property, social and individual interests are perpetually in conflict. 3. M. de Montalembert, in the Chamber of Peers, vehemently protested against the assimilation of authors to inventors of machinery, an assimilation which he claimed to be injurious to the former. M. Wolowski replies, that the rights of authors without machinery would be nil; that without paper mills, type foundries, and printing offices, there could be no sale of verse or prose; that many a mechanical invention, the compass for instance, the telescope, or the steam engine, is quite as valuable as a book. Prior to M. Montalembert, M. Charles Comte had laughed at the inference in favor of mechanical inventions, which logical minds never fail to draw from the privileges granted to authors. He, says M. Comte, who first conceived and executed the idea of transforming a piece of wood into a pair of sabots, or an animal's hide into a pair of sandals, would thereby have acquired an exclusive right to make shoes for the human race. Undoubtedly, under the system of property. For, in fact, this pair of sabots over which you make so merry is the creation of the shoemaker, the work of his genius, the expression of his thought. To him it is his poem, quite as much as Le Roi sans Mousse is M. Victor Hugo's drama. Justice for all alike. If you refuse a patent to a perfecter of boots, refuse also a privilege to a maker of rhymes. 4. That which gives importance to a book is a fact external to the author and his work. Without the intelligence of society, without its development, and a certain community of ideas, passions, and interests between it and the authors, the works of the latter would be worth nothing. The exchangeable value of a book is due even more to the social condition than to the talent displayed in it. Indeed, it seems as if I were copying my own words. The proposition of M. Wolowski contains a special expression of a general and absolute idea, one of the strongest and most conclusive against the right of property. Why do artists, like mechanics, find the means to live? Because society has made the fine arts, like the rudest industries, objects of consumption and exchange, governed consequently by all the laws of commerce and political economy. Now, the first of these laws is the equipoise of functions, that is, the equality of associates. 5. M. Wolowski indulges in sarcasm against the petitioners for literary property. There are authors, he says, who crave the privileges of authors, and who for that purpose point out the power of the melodrama. They speak of the niece of Corneille, begging at the door of a theatre which the works of her uncle had enriched. To satisfy the avarice of literary people, it would be necessary to create literary majorats and make a whole code of exceptions. I like this virtuous irony. But M. Wolowski has by no means exhausted the difficulties which the question involves. And first, is it just that Messrs. Cousin, Guizot, Villemain, Demiron, and company, paid by the state for delivering lectures, should be paid a second time through the booksellers? That I, who have the right to report their lectures, should not have the right to print them? Is it just that Messrs. Noël and Chafsal, overseers of the university, should use their influence in selling their selections from literature to the youth whose studies they are instructed to superintend in consideration of a salary? And, if that is not just, is it not proper to refuse literary property to every author holding public offices and receiving pensions and sinecures? Again, shall the privilege of the author extend to irreligious and immoral works, calculated only to corrupt the heart and obscure the understanding? To grant this privilege is to sanction immorality by law; to refuse it is to censure the author. And since it is impossible, in the present imperfect state of society, to prevent all violations of the moral law, it will be necessary to open a license office for books as well as morals. But then 3/4 of our literary people will be obliged to register, and recognized thenceforth on their own declaration as prostitutes. They will necessarily belong to the public. We pay toll to the prostitute; we do not endow her. Finally, shall plagiarism be classed with forgery? If you reply yes, you appropriate in advance all of the subjects of which books treat. If you say no, you leave the whole matter to the decision of the judge. Except in the case of a clandestine reprint, how will he distinguish forgery from quotation, imitation, plagiarism, or even coincidence? A savant spends 2 years in calculating a table of logarithms to 9 or 10 decimals. He prints it. A fortnight after, his book is selling at half price. It is impossible to tell whether this result is due to forgery or competition. What shall the court do? In case of doubt, shall it award the property to the first occupant? As well decide the question by lot. These, however, are trifling considerations; but do we see that, in granting a perpetual privilege to authors and their heirs, we really strike a fatal blow at their interests? We think to make booksellers dependent upon authors a delusion. The booksellers will unite against works, and the proprietors against works, by refusing to push their sale, by replacing them with poor imitations, by reproducing them in 100 indirect ways; and no one knows how far the science of plagiarism and skilful imitation may be carried. Against proprietors. Are we ignorant of the fact that a demand for a dozen copies enables a bookseller to sell 1,000; that with an edition of 500 he can supply a kingdom for 30 years? What will the poor authors do in the presence of this omnipotent union of booksellers? I will tell them what they will do. They will enter the employ of those whom they now treat as pirates, and, to secure an advantage, they will become wage laborers, a fit reward for ignoble avarice and insatiable pride. [Footnote: The property fever is at its height among writers and artists, and it is curious to see the complacency with which our legislators and men of letters cherish this devouring passion. An artist sells a picture, and then the merchandise delivered assumes to prevent the purchaser from selling engravings, under the pretext that he, the painter, in selling the original, has not sold his design. A dispute arises between the amateur and the artist in regard to both the fact and the law. M. Villemain, the Minister of Public Instruction, being consulted as to this particular case, finds that the painter is right, only the property in the design should have been specially reserved in the contract. So that, in reality, M. Villemain recognizes in the artist a power to surrender his work and to prevent its communication, thus contradicting the legal axiom, one cannot give and keep at the same time. A strange reasoner is M. Villemain. An ambiguous principle leads to a false conclusion. Instead of rejecting the principle, M. Villemain hastens to admit the conclusion. With him, the reductio ad absurdum is a convincing argument. Thus he is made official defender of literary property, sure of being understood and sustained by a set of loafers, the disgrace of literature and the plague of public morals. Why, then, does M. Villemain feel so strong an interest in settling himself up as the chief of the literary classes, in playing for their benefit the rôle of Tristan in the councils of the state, and in becoming the accomplice and associate of a band of profligates, soi-disant men of letters, who for more than 10 years have labored with such deplorable success to ruin public spirit, and corrupt the heart by warping the mind? Contradictions of contradictions! Genius is the great leveller of the world, cries M. de Lamartine. Then genius should be a proprietor. Literary property is the fortune of democracy. This unfortunate poet thinks himself profound when he is only puffed up. His eloquence consists solely in coupling ideas which clash with each other: round square, dark sun, fallen angel, priest and love, thought and poetry, genius and fortune, levelling and property. Let us tell him, in reply, that his mind is a dark luminary, that each of his discourses is a disordered harmony, and that all his successes, whether in verse or prose, are due to the use of the extraordinary in the treatment of the most ordinary subjects. Le National, in reply to the report of M. Lamartine, endeavours to prove that literary property is of a quite different nature from landed property, as if the nature of the right of property depended on the object to which it was applied, and not on the mode of its exercise and the condition of its existence. But the main object of Le National is to please a class of proprietors whom an extension of the right of property vexes. That is why Le National opposes literary property. Will it tell us, once for all, whether it is for equality or against it? 6. Objection. Property in occupied land passes to the heirs of the occupant. Why, say the authors, should not the work of genius pass in a like manner to the heirs of the man of genius? M. Wolowski's reply: because the labor of the first occupant is continued by his heirs, while the heirs of an author neither change nor add to his works. In landed property, the continuance of labor explains the continuance of right. Yes, when the labor is continued; but if the labor is not continued, the right ceases. Thus is the right of possession, founded on personal labor, recognized by M. Wolowski. M. Wolowski decides in favor of granting to authors property in their works for a certain number of years, dating from the day of their first publication. The succeeding lectures on patents and inventions were no less instructive, although intermingled with shocking contradictions, inserted with a view to make the useful truths more palatable. The necessity for brevity compels me to terminate this examination here, not without regret. Thus, of two eclectic jurists, who attempt a defense of property, one is entangled in a set of dogmas without principle or method, and is constantly talking nonsense; and the other designedly abandons the cause of property in order to present under the same name the theory of individual possession. Was I wrong in claiming that confusion reigned among legists? And ought I to be legally prosecuted for having said that their science henceforth stood convicted of falsehood, its glory eclipsed? The ordinary resources of law no longer sufficing, philosophy, political economy, and the framers of systems have been consulted. All the oracles appealed to have been discouraging. End of Second Memoir, Part 7.